In India, Parliament and state legislature is responsible for discussing bills which become law with the assent of president or governor, as the case may be. But what happens when the governor or even the president just sits on a bill passed by a state assembly? Can they delay it forever? What does the constitution lay in this regard? Recently, the Supreme Court of India prescribed a timeline for governors and the president in a way to convey stop stalling and decide a yes or a no. In response, the President of India has done something extraordinary. She has asked the Supreme Court 14 big questions that could change how constitutional powers are interpreted in India. Let's break it all down simply, clearly, and with a touch of clarity. Several state governments like Tamil Nadu and Punjab accused their governors of indefinitely delaying the bills, not approving them, not rejecting them, just letting them sit. Article 200 of the Constitution gives a governor four options when a bill is presented. First, either give assent, withhold assent, reserve it for the president, or return it to the legislature for reconsideration if it is not a money bill. But there is no timeline mentioned. That's a loophole. The Supreme Court in a recent ruling said that this is against constitutional morality. You cannot just do nothing. They even directed that the president too must act swiftly on reserved bills. And that's where things got a bit tricky. The President, using Article 143 of the Constitution, has now asked the Supreme Court to formally clarify several key issues. Article 143 allows the President to seek the advice of the Supreme Court on questions of law or public importance. This is called a presidential reference. This is rare but not unheard of. It's how landmark opinions like the Beru-Perry Union case or the Ninth Schedule issue were dealt with. Now let's go through what exactly the Supreme Court has been asked by the President. What exactly can a governor do under Article 200? Can the governor disregard the advice of the State Council of Ministers? Is their discretion judicially reviewable? Does Article 361, which gives immunity to the governor, mean that courts cannot touch their decisions? Can courts impose deadlines if the Constitution does not? What about the President's role under Article 201? Can he be reviewed? Can courts also set timelines for him? Does the President have to consult the Supreme Court when a bill is reserved for his assent? Can courts interfere with a bill before it becomes a law? Is it premature to judge a bill before assent? Can Supreme Court orders under Article 142 override or substitute presidential or gubernatorial powers? Can a law passed by the state legislature be considered in force without the governor's assent? Should constitutional questions always go to a 5-judge bench as per Article 145 Clause 3? Are Article 142 powers limited to procedure, or can they override substantive laws? Can the Supreme Court reserve center-state disputes outside Article 131, which provides for original jurisdiction? These questions go straight to the heart of India's federal structures, separation of powers, and the limits of judicial review. This is not just a legal quiz for the constitution nerds. These answers will decide how powerful governors really are, whether state governments are at mercy of the unelected appointees, how far the Supreme Court can go to enforce action on stalled laws, and whether the President of India and state governors are beyond judicial accountability or answerable under a constitutional democracy. This could set precedents that shape India's politics and law for decades. So next time you hear someone say the governor is sitting on the bill, you'll know exactly what that means and why it matters. This is not just a tug of war between the court and the executive. It's the constitution in action. Follow for more bite-sized breakdowns of big legal stories, and let us know in the comments, should the president and the governors be time-bound too?